compendium, Your Lordship. I would like to bring my Lord's attention to page number 13 of the compendium, para number 17. Page number 13, para number 17. Your Lordship, this abstract is from the case of S.P. Gupta versus Union of India. In this, it states in a summary that where a legal wrong or a legal injury is caused to a person or to a determined class of persons who by reason of poverty, helplessness or disability or socially or economically disadvantaged position cannot approach the court for relief, any member of the public or organization can file an application in the appropriate direction. Your Lordship, under the PIL, the locus standi can be interpreted in a broad way only if there is a determinate class of disadvantaged people who require urgent legal remedy, Your Lordship. Your Lordship, this incident is not in this petition, Your Lordship, where the cardinal question arises that what is the legal injury, who are the aggrieved parties, and if the petitioner is actually representing this aggrieved party. Your Lordship, the answer to all these three questions is no. It's because the current 130th amendment actually affects the ministers, be it the PM, the CM, the state or union ministers who face the risk of removal if they're prosecuted under a case, a serious offence having punishment of 5 years or above. Your Lordship, these ministers in no way can be considered to be a part of a marginalized, vulnerable group who cannot approach the court. Your Lord, it's on the contrary that these are people who have a lot of power, have a lot of legal capacity to go and approach the court. Hence, the petitioner NGO cannot claim to represent a weaker class, deprived section, or a determined group who cannot approach the court. There are also a lot of genuine public interest litigations, such as the Bandhwa Mukti Morcha case, where the petitioners represented a group of bonded laborers in these quarries in Haryana who faced a lot of exploitation, very harsh working conditions, who were robbed of their right to life and dignity, which is given on Article 21. Here, Your Lordship, there is a determined group of people whose fundamental rights are being violated. Even in the case of Olga Tellis case, which is almost famously known as the pavement dwellers case, where the petitioners defended and represented thousands of poor who faced imminent eviction from their shelters. And even this gave a threat to their livelihood and shelter under Article 21. All these cases, Your Lordship, have identifiable victims, traceable harm, and urgent constitutional remedies which they require. On the other hand, in stark contrast, Your Lordship, the petitioner NGO in the present case does not represent any class that are from a vulnerable class or marginalized class who have any kind of violation of their fundamental rights. Here, this is why, Your Lordship, the petitioner lacks the requisite locus standi. Your Lordship, all of the petitioner's arguments are speculative in manner, that the centre might use this to topple the state governments, this act might be misused. Your Lordship, it is a well-known doctrine that mere speculation of misuse of a law cannot be a reason to sort of call it unconstitutional or to quash the law, Your Lordship. Your Lordship, this 130th amendment was passed by elected parliament, ratified by the states, assented by the president, and even published in the Gazette. This entire amendment has been passed in a very democratic manner, Your Lordship. Your Lordship, democracy will not be violated if a minister is temporarily removed for being arrested and detained for a serious offence. But democracy will certainly be violated if a constitutional amendment is struck down merely because the petitioner doesn't agree with its policy functions, Your Lordship. Your Lordship, there's a lot of questions regarding the threshold of 30 days. Your Lordship, here 30 days should not be seen as with a numerical pecuniary way. Your Lordship, the question is not about 29 days or 30 days or 31 days. Here, Your Lordship, the doctrine of Your Lordship, moving on to
Attorney General, it seems you are Attorney General and Solicitor General of India. What was the need of introducing this constitutional amendment? See, for example, if PM or CM or Minister Council of Ministers, maybe in Union of India or state, if he is complained of commission of some cognizable offence and he is sent to the judicial custody, then what's the need of introducing this constitutional amendment instead of that the CM or the PM would have advised the Prime Minister or the Governor to just place him under suspension or just ask him to resign for the post or just keeping him away from his duties for till the trial is concluded. That option is always there with the PM or the CM. They would advise the Governor or the President. Then if such kind of thing is available, then what is the need of introducing this constitutional amendment, which is against the basic principle, foundational principle of adversarial jurisprudence, criminal jurisprudence, that the accused is presumed to be innocent till the guilty is proved. Then what is the need of introducing this, despite there being some dissent from so many corners of this society?
Indeed, Your Lordship. Here, Your Lordship is trying to refer to the pleasure of the President to remove any minister on the advice of the Prime Minister, or the pleasure of the governor to remove the minister on the advice of the Chief Minister. Your Lordship, but what we don't realize is this is a totally discretionary power, and that, Your Lordship, is what led to this sort of 113 amendment, because we see that, Your Lordship, there's even a statistic which says that in 2024, out of the 534, Your Lordship, out of the 543 winning candidates in the 2024 general election, 251 members of the Parliament had declared criminal cases against themselves. That is around 46% of the entire Parliament, Your Lordship. And even I'm assuming that some of these have wanted to become ministers. But Your Lordship, what is happening is that this president or this government are not really using the discretionary power. Even if they feel like some minister in their cabinet has some kind of issues with moral turpitude, they are kind of, I would say, putting it in a blind spot or favoring them and not removing them, Your Lordship. And that is when we realize that there needs to be a mechanism where on the 31st day, if the president has not removed this minister, there needs to be a mechanism where there's automatic removal. Because we can't wait indefinitely on the basis of a discretionary power given to the president and wait. Because, Your Lordship, but the advice might never come, Your Lordship, and the case might go on, and the entire tenure of the minister may go on, and the people will be represented by.
How do you justify that this 30 days period is a sufficient period to come out either from granting a bail from the court? Because in NDPS cases, 180 days is the default period, and in cognizable cases where the punishment is beyond 10 years, that is 90 days, and punishment is below 10 years, that is 60 days, is even as per the new BNSS 187 2, 1 and 2. What was the reason given for a short time like 30 days? It's neither contemplated under the BNS or the CRPC, nor contemplated under any other provisions. Stringent penal provisions are there, which provide for 90 days, 180 days, 60 days. What was the reason for 30 days, just giving 30 days? How do you feel that this is a sufficient buffer time for the ministers or the PMs or CMs?
Your Lordship, 30 days is thought of to be a much more reasonable time than Your Lordship itself presented that in the case of these government employees, if they are under custody for 48 hours, they're already suspended, Your Lordship. In this case, these ministers have been given a much greater allowance time of 30 days. Your Lordship, as we realize that police custody under the BNS,
as rightly pointed out by the other your opponent counsel, see, in case of public servants, if they are kept in the judicial custody for beyond 48 hours, there is an automatic suspension. But they have a remedy under the relevant provisions of the Tribunals Act, Central Administrative Tribunals Act, etc. They can approach the tribunals, and they can also come to the High Court. In Andhra Pradesh, there is no Administrative Tribunals Act. They can approach the court, and they can get that suspension set aside. That provision is there for the public servants, whereas that kind of leverage liberty is not there for the political people, politically elected people, MP, MLAs, that kind of the facility is not there. Then
Your Lordship, in that case, Your Lordship, these government employees have the chance of, they don't have the chance of getting reappointed, Your Lordship. Only after the judgment is given, the sort of suspension is removed.
they can get the suspension order set away. They can get the reinstatement order.
But Your Lordship, the amount of social responsibility that a minister has is way more than a government employee, Your Lordship. Because these government employees work for the government and the ministers themselves are considered as the government, Your Lordship. Hence,
Yes, you can proceed with your other contentions.
Your Lordship. So if Your Lordship is satisfied with issue number 1, permission to move to issue number 2. Your Lordship, issue number 2 states whether the impugned 130th Constitutional Amendment Act is in violation of the basic structure of the Constitution of India. Your Lordship, the 130th Amendment does not violate the Constitution. It actually shields it. The 130th Amendment doesn't sort of erode the basic structure, but actually tries to reinforce it. Your Lordship, it is humbly submitted that the 130th Amendment Act does not violate the basic structure. This is because, Your Lordship, under Article 368 of the Constitution, the Parliament has been given plenary powers to amend any part of the Constitution except the basic structure. Even as in held in the case of Keshavananda Bhati versus State of Kerala, this Honourable Court itself said that, subject to the retention of the basic structure, the power to amendment is plenary. This was also held, the case of Keshavananda was also again applied in the case of Vamanrao versus Union of India, where this court reiterated that the power of amendment is not restricted except to the extent of not damaging the basic structure. Your Lordship, in this case, the 130th Amendment has not tried to violate or has not violated the basic structure in any way. Hence, the powers that the Parliament has utilized comes under the purview of 368. Now, to explain, Your Lordship, how this 130th Amendment has not sort of violated the basic structure is because one of the core principles of basic structure is federalism, which explains the center-state relationship. Your Lordship, the petitioner's contention was the center can use this as a weapon to destabilize the state government. But Your Lordship, this 130th Amendment applies equally to the center and state. It applies equally to the Prime Minister and Chief Minister, applies equally to the State or Union Minister. This act doesn't empower the state or doesn't empower the center over the state in any way. Hence, Your Lordship, the system of federalism is not violated because there's no sort of asymmetrical power difference between the center and state. As much as this 130th Amendment can remove the PM, it can remove the CM. You're moving on, Your Lordship. Separation of powers is another basic structure. Where the petitioner argued that the legislature or the executive is trying to encroach the powers of the judiciary. Your Lordship, if you come to this situation itself, I will tell you how the separation of powers is very well respected and is kept in its domain itself. Your Lordship, here the legislature has passed the 130th Amendment for causes of helping decriminalization and for good governance, so that democracy is not affected. Your Lordship, judiciary deals with topics such as arrest, bail. Your Lordship, that sort of purview is not being implicated because the legislature or the executive in no way send the judiciary whom to arrest, to give the bail or not, or to not give the bail, Your Lordship. So the judiciary is carrying on with its domain. The executive is following due process or agreeing to the orders given by the judiciary. Hence, there's no sort of overlap or interference between the three pillars of our government, Your Lordship.
Knowledge of law question. Which judgment of us, Supreme Court of India, says about federalism is the basic structure of the Constitution of India. And which judgment of us laid down that separation of powers is the basic structure of the Constitution of India.
Indeed, Your Lordship. In the case of S.R. Bombay versus Union of India, it was held that states are not mere appendages of the center. Federalism is a part of the basic structure.
Very good.
Now, just one or two doubts that I have. First issue is, you said bail is always available. Who's stopping them from getting bail? In most political cases or cases where MLAs, MPs, ministers are involved, these are cases initiated under the Prevention of Money Laundering Act, etc. Now, there, the provision says that you will not be given bail unless you demonstrate you are innocent. So then where is the bail available there at all? So any person who is arrested under the PMLA Act invariably will not be able to demonstrate that he is innocent and should be released on bail. So isn't that a case where no bail is really available except in extreme cases where it can be very clearly demonstrated? Now that is the first issue. The second issue is somebody is accused of a crime. Let's say murder, but he is still made the chief minister of the state on the ground that he is innocent until it is proven. Here, what you are saying, he is allowed to continue as chief minister or minister. But the minute he is arrested, you are saying he ceases to be chief minister after 30 days. He is still not proved to be guilty. He is still innocent until proved guilty. So that means you have created two categories of people without any intelligible definition. Simply saying because he is arrested, how does it put him at a lower step than that? Then there is a violation of Article 14.
Could I move on to the
Yes,
answer? Your Lordship, answering your second question, stating, Your Lordship, as I already expressed my view that the 130th Amendment is not trying to prove if this minister is guilty or innocent. That is the judiciary's work. All we are saying is that once the 30th day threshold is passed, governance starts to get affected, Your Lordship. The mere reason why he is being removed from his post is that democracy is coming to a standstill. His portfolio has come at a stall. Because, Your Lordship, these are all offences having punishment of 5 years or above. Your Lordship, when as we know that under BNSS, police custody can be kept only for 15 days, Your Lordship. Your Lordship, then when another bail petition is put up in front of your honourable judge, Your Lordship, the judge itself knows that if I pass another 15-day extension, this minister is going to lose his portfolio. Your Lordship, then the judge is probably going to reflect that is the prima facie case so strong that if I don't give him bail, then tomorrow he loses his ministership, Your Lordship. If the judge feels that no matter what, even if at the cost of him losing his ministership, he needs to be under judicial custody because there is a high chance that this person might go out on bail, sort of manipulate the evidences, or the case against him is so strong that he should not go out on bail, Your Lordship. This itself sort of gives us an idea that the judiciary itself might sort of try to filter out that if the not giving bail, because Your Lordship, in normal cases, giving bail or not giving bail doesn't have the kind of consequences that it will have in this case. In this case, Your Lordship, if bail is not given, a chief minister might lose his position, the entire state government might topple. Even that time, the judiciary might think that only if the prima facie case or the offence is so strong that regardless of the consequences, he needs to be under custody, then Your Lordship, we need to make sure that the procedure is upheld and everything is intact, Your Lordship.
Very well. Please continue.
Moving on, Your Lordship, I want to bring Your Lordship's attention to page number 5 of the compendium and subsequently to page 7 of Article 102 and 191. Your Lordship, these 102 lays down certain disqualifications for members of Parliament, such as a minister who wants to become a member of Parliament can't hold an office for profit, etc. Your Lordship, in the clause number E says, all other disqualifications may be prescribed by Parliament through legislation. Your Lordship, the Constitution itself sort of empowers the Parliament to make certain disqualifications of, say, MLAs or MPs. Your Lordship, it itself sort of empowers the Parliament to make extra disqualifications that are already not present. So, Your Lordship, how can we say that the 130th Amendment is going against the basic structure when the Constitution itself is giving it the power to use a ethical qualification in a constitutional way, Your Lordship? This is merely a temporary ineligibility, not any kind of accusatory pose against if he is accused or not. Your Lordship, I would like to conclude my arguments of issue 1 and 2 by saying that, Your Lordship, ministers are not mere citizens. They are the trustees of our constitution. And when such a trustee of our constitution is under custody for a serious offence for 30 days, Your Lordship,
language of the amended provision, removal or disqualification.
Your Lordship, it is removal. But
Is
it
it
is a temporary cessation.
Removal from the
Indeed.
date of 31st day till his release.
Indeed, Your Lordship.
Only temporary cessation.
Indeed.
He can be reinstated after release.
Indeed.
Only temporary cessation.
Indeed.
It's not a disqualification
Indeed.
from holding post in future after release.
Indeed, Your Lordship.
This
Your
comes-
Lordship. The Lordship, question number 4 is that whether the impugned 130th Constitutional Amendment Act strikes at the foundational principle of criminal jurisprudence, enunciating that an accused is presumed innocent until proven guilty. The Lordship, in the present case, the doctrine of presumption of innocence does not come into picture, Your Lordship, because the 130th Amendment Act is completely about the constitutional qualification, and the doctrine of presumption of innocence is completely based on the criminal jurisprudence. Hence, Your Lordship, this principle does not exist in this present petition. And Your Lordship, the Council's contention is that the disqualification or the removal from public office by this Amendment Act is just a regulatory measure and not punitive in nature. Your Lordship, it is just taken in order to protect the integrity and the governance of the state. It is not punitive step to intend or to punish the ministers, rather to uphold the democracy. Your Lordship, in India has among the highest rates of legislators with criminal cases. According to the comprehensive analysis of the Association of Democratic Reforms and National Election Watch, of all 543 in the 2024 general election, 251 members of the parliament, about 46% had declared criminal cases against themselves, up from 43% in 2019, 34% in 2014, 30% in 2019, representing a 55% increase over 15 years. Here, the bluntness of this approach risks the undermining both the principle of fairness and the stability of the governance. Hence, Your Lordship, this Amendment Act would serve better in order to clean these criminalization in politics, as well as in order to not erode the democratic safeguards. Hence, Your Lordship, this Act, by imposing stricter standards on ministers, signals a commitment to ethical governance and may deter candidates with tainted backgrounds from seeking executive posts. Your Lordship, the Honorable Court has consistently held in Gudikanti Narasimholo versus the public prosecutor that detention prior to conviction exists only to ensure the accused presence at trial, prevent interference with evidence, or maintain public order, and there is no imputation of guilt. Your Lordship, we the government does not question whether the arrested minister is innocent or not. The only concern of ours is that the democracy or the governance should not be affected. Hence, the bench is satisfied with the issue number 4, Council seeks permission to move towards the last issue. Issue number 5 is that whether the implementation of the impugned 130th Amendment Act results in the weakening of the democratic process in the Republic of India, warranting its setting aside. Your Lordship, it is humbly submitted before this Honorable Court that the impugned 130th Amendment Act does not weaken the democratic process, instead it strengthens the democratic process, as it aims to decrease the criminalization in politics, as well as it fulfills the test of doctrine of proportionality. First ground, Your Lordship, is that it decreases the criminalization of politics, which threatens the democratic integrity. Your Lordship, for this, in S.R. Bommai versus Union of India, the Supreme Court of India underscored the role of constitutional
it provides a constitutional framework for evaluating whether a law or an amendment weakens the democratic process. Justice Chandrachud held that democracy under the Indica's constitution is sustained by the principle of liberty, dignity, autonomy and accountability, and that the state action restricting these values must satisfy the fourfold proportionality test, that is legality, legitimate aim and the proportionality and the procedural safeguards. Your Lordship, I humbly submit before this Honorable Court that the 130th Amendment does not damage the democratic because it satisfies the above test. First, Your Lordship, the amendment is empowered under the constitutional procedure for amendment as per Article 368 of the Constitution. It seeks to modify the existing constitutional provisions such as Article 75, 164 and 239A of the Constitution, which is within the Parliament's limit. Thus, it satisfies the first requirement of the legality. Second is that democratic governance depends upon trust, accountability and legitimacy of office holder. This amendment aims to prevent to preserve the constitutional morality and public trust in governments by opposing this criminalization in politics. Thus, it satisfies the legitimate intent. Third, Your Lordship, the amendment does not permanently bar the person once released. Reappointment is possible. Thus, it does not permanently punish on mere accusation. So, it also satisfies the third requirement of proportionality. And lastly, the amendment provides a structured and procedural constitutional procedure for, which is not arbitrary or discretionary removal. Thus, it also satisfies the fourth ground, that is procedural safeguards. With this, Your Lordship, in the last case, the bench may refer to page 84, 115th para, where in People's Union of Civil Liberties versus Union of India, the court held that reforms strengthening transparency or justice administration enhance democracy, not diminish it. By saying this, Your Lordship, it is humbly submitted that the 130th Amendment Act aims to decrease the criminalization in politics and to stabilize the democracy of Indica. If the bench is satisfied with all the issues, counsel would like
I have some issues. Please clarify this. The Article 21 says right to life and liberty. That has now been expanded to mean that you should be given all the available possibilities of ensuring that you develop to your fullest. Part of that will also remain that whoever I vote for should be sitting in office. Here, the person I have voted for, after knowing he has a criminal background, is allowed to sit in office. You are now coming up with a provision which says that if he is arrested, he can't sit in office. How? Because in both cases it should be the same. Why should this simple act of arrest make it a bigger thing? You are now creating a clear-cut distinction. And how does that answer this intelligible differential? Intelligible differential, just because he is arrested doesn't make it intelligible differential. He is still innocent until you prove it. So why should he be removed? Just because he is arrested or, under the PMLA or UAPA, they won't come out on bail at all. In most cases.
Your Lordship, the council would answer to this. As I already mentioned, we respect the doctrine of pleasure. How the ministers are appointed, in the same way we have given the provision for the procedure for removal to the same procedure. When the president or the governor do not, or the prime minister or the chief minister do not recommend for the removal of the minister, which shows the discretionary power in the hands of
It's not a question of discretion. See, person is appointed as minister. Let us take the case of a minister. Person is appointed as a minister despite a criminal background. You allow him to continue. You are not touching such a person. Right? What are you doing? You are now saying, if he is arrested and he remains in jail for 30 days, I'll remove him. Stands removed, there is no discretion left at the end of 30 days. So how do you explain this classification? What is the difference except his point of arrest?
Your
Your Lordship, the main contention, firstly, Your Lordship, that voting is a statutory right and not a fundamental right, Your Lordship. So, the end of the day, the contention is that democracy and the people's electoral vote is being undermined. But Your Lordship, looking at the bigger public picture, where Your Lordship, governance is being affected. Your Lordship, in the case where the people, we can't let our society go to a point that this already we're at a situation where people are winning elections from sitting in the jail, Your Lordship, or the CM for that matter is ruling his constituency, sitting from jail for 6 to 8 months. So, Your Lordship, there needs to be some kind of procedure set. Your Lordship, about the part of him not being heard before being removed, Your Lordship. Your Lordship, the concept of natural justice and the chance to be heard comes under when there's a trial or there's some kind of adjudication process. Your Lordship, that is going to be held by the judiciary when he'll be given his chance to be heard. Your Lordship, this is merely a regulatory feature. Just because, Your Lordship, what happens is our disqualification is a consequence of what the judiciary decides. If pardon the Lordship, if the judiciary decides to arrest a person, says that his arrest is valid,
Judiciary never decides who's to be arrested.
indeed, Your Lordship, decides if the
Investigating
arrest
officer
is
decides.
valid, decides if the arrest is valid and keeps him in custody for 30 days. As a consequence of that, Your Lordship, we are not holding him accountable of guilt or
So
anything.
let us look at it the other way. To take your argument for this. I am innocent till proved guilty. I am arrested. I am still innocent. I am still innocent.
Indeed,
I am not guilty.
indeed not.
Then why are you creating a disability on me?
Your Lordship,
You are creating a disability of saying remove me as minister. How do you create that disability?
Your Lordship, because at the cost of him, democracy is suffering. When he is
Democracy was
arrested,
anyway suffering if a criminal person with a criminal background is allowed to sit as a minister or chief minister.
indeed, Your Lordship.
Then-
So when a minister is under mistaken arrest and kept under custody, there is no sort of definite way when he is going to come out. The entire state is under suspension and there's a lot of confusion within the government. So it's better that he is removed from his post. Keeping in mind that once he is come out of custody, Your Lordship, the reason why I've kept this reappointment is because we just want the person to be outside and govern the people for which he is chosen. So the second this person comes out, we allow him to take up his post and govern the people. Just when he's under custody and he can't come out, we're saying that at the 31st day, you are removed and we need to appoint someone else so that governance continues. Lordship, that is the only reason good governance and democracy should not be harmed.
Ruling from prison is prohibited. Ruling from prison is prohibited.
It is not, Your Lordship, but the people of India deserve better than having a representative who's
Then all these people who have been elected to parliament or assembly should be then removed. If that is the principle that is to be
Your
applied.
Lordship, it is a
That just
process
because
of
somebody
slow
files a complaint.
decriminalization.
See, somebody files a complaint, then the route is very simple. Whoever gets elected, I'll file a complaint, and he stands removed.
But Your Lordship, it's under the guidance of the magistrate who agrees if this arrest is valid or just flimsy, Your Lordship. 30 days threshold is being given.
Very well. Now,
Where do you want to from ruling? Secretariat or prison? After is given to the minister. If you want to rule from prison, go out of it. If you want to rule from secretariat, away from criminal.
Indeed, Your Lordship. That's the process. We just want to
Now,
take this message.
since we are supposed to also look at your knowledge of law, you cited R.C. Cooper. So can you elaborate what is the principle of locus standi that was explained in R.C. Cooper? There is no difference. It's a little complicated. That's why I was asking. See, the difficulty there was Article 19 does not apply to non-citizens. It applies only to citizens. So R.C. Cooper is the bank nationalization case. But what happened was, the banks were nationalized. A bank or a company is not a citizen. So the company can't file a writ. And in those days, there's no question of expansion of locus standi. Only person affected had to file a writ. So what they did was, they made Mr. R.C. Cooper, who was a shareholder in one of the companies, to file that case, saying though company has lost because my shareholding in the company is affected, the value of my shares in the company get affected because the company loses banking license and the bank is taken over, I should be allowed to file a writ. That was accepted. That is why whenever a company files a writ petition, though it is observed in the breach in our courts, one of the shareholders should be a party. Because otherwise Article 19 can't be raised by any non-citizen. Only a citizen can claim protection under 19. That is the principle.
Council is entitled to claim.
Council seeks permission to move towards the prayer remarks. In the lights of facts stated, arguments advanced and authorities cited, the respondents humbly place before this honorable court may please to declare the present petition, to dismiss the present petition and pass any order which the honorable court may deem fit in the light of justice, equity and good conscience. All which is humbly prayed.
Yes.
Rebuttal.
The council humbly seeks permission for rebuttal. Much obliged, Your Lordship. The Law Council have vehemently submitted their submissions against the client. For a better understanding of the law, the Petitioners Council would like to give clarifications to the Law Council. Much obliged, Your Lordship. Your Lordship, the word temporary, the first condition, first clarification is regarding the word, as the word temporary is not there in the, even in the proposition, even in the bill, Your Lordship, the word temporary is not there. So the removal is itself the disqualification, Your Lordship. Because nothing in the, Your Lordship, nothing in the no bar or reappointment clause, that nothing in that clause is giving the word temporary, Your Lordship. And that also can be, the language that is used can be equated under MPMLA disqualification, that shall be ceased to hold office. So that language can be used, Your Lordship. So with that similarity, it means that removal is equal to disqualification. And also, Your Lordship, the Law Council has stated that it's a mere speculation, Your Lordship. But and also there's the operation of statute in article, the operation of the statute of legislation. But Your Lordship, the operation of statute of legislation must not be to harm the public, Your Lordship, must not be harm the citizen, Your Lordship. And also, Your Lordship, a ministerial office doesn't nullify the fundamental rights. Your Lordship, the first clarifications regarding that also, Your Lordship. Ministerial office doesn't nullify the fundamental rights. The Respondent Council, the learned friend had stated that there is no harm, and also ministers are also not citizens. But Your Lordship, in Vidadala Harinanda Babu was Ramarao, in that case, a citizen is not deprived of his fundamental rights guaranteed to him by Part 3 of the Constitution merely because he accepts the office of a minister. Your
But Your Lordship, we have the council had stated in that case, even the learned councillor also stated ED abuse reports, I mean the reports of ADR report. So this ADR report is substantiated in the, Your Lordship, in the deprivative article 19, that case, in the submissions, abuse of power and disproportionality is there. It is also cited in 500 cases registered by Enforcement of Directorate. Previous 5 years recorded only less than 10% convictions. Politically motivated detentions are amplified, which undermines the whole electoral process and the electoral mandate. Citing data report, this is not mere speculation, Your Lordship. Citing data report, I am stressing on the fact that citing data report from PRS legislative research, only 2 convictions registered out of 193 profile cases involving politicians. Conviction rate is just 1%, Your Lordship. I am stressing on the fact that conviction rate is just 1%. Then how come, Your Lordship, this becomes a mere speculation of the petitioner's argument? Also, Your Lordship, clearly there's a prejudice and there's a personal bias in this case, because it's violating the natural justice principles, and thereby it is eroding the federalism also, Your Lordship. And this is a revolving door problem is there because it's a super emergency. They are using this the article 356 is being used to weed out the state missionary, to weed out them, and also shielding out the allies and targeting it to the political rivals. Also, in section 351 of DNSS further reinforces this protection by allowing the accused to explain incriminating circumstances and failure to put essential question causing prejudice as recognized with Anwasi versus State of Punjab. Your Lordship, and also this is there are if this is not the least restrictive measure, Your Lordship. There is interim suspension, and also if coming to the public servant case, they can go for central administrative review. Such judicial scrutiny is not here absent, Your Lordship. That submits council submissions. Much obliged, Your Lordship.
Council seeks permission to counter the rebuttals. Much obliged. Your Lordship, regarding the point that there's only, out of the entire statistic, that only 2 people have been convicted. Your Lordship, again, as you said, we're not considering the people who have been convicted or not. But Your Lordship, what if the 197 people? Who's going to say the statistics about how long these people were in custody? Your Lordship, maybe at least if 10 of them were in custody for about 6 months, Your Lordship, who is going to take accountability of the government?
facts come out. Some of them are complicated, some of them are simple. But the bottom line of what you should see is, what is the case which can be, what is the principal issue in the case? You know, one way of doing it is if you can distill the entire case into 4 lines or 5 lines and say this is the dispute that has come up, and then you start working on that, it becomes so much easier. Now, for example, when you were arguing, first question is, this is supposed to be in the Supreme Court under Article 32. So under Article 32, only cases where fundamental rights are affected can be moved. You can't move for other purposes which is available in the High Court. The jurisdiction of the High Court is much larger compared to the jurisdiction of the Supreme Court. So the question that you should ask is, whose fundamental rights are affected? What are the fundamental rights that are affected? Now, all of you argued on 14, 19, 21, right? But none of those issues come up for a legislator, except to some extent Article 14. There is no fundamental right under 19 to stand for election or to hold office. 21 is nowhere near the picture. So the only distinction that you could have drawn was on 14. All of you went into all the fundamental rights. That was not, really speaking, available in this case. Secondly, when you were arguing, you kept arguing on fundamental rights. Now, it's very clear that no legislature has a fundamental right to be appointed as a minister or the chief minister. Removal doesn't mean anything as far as fundamental rights are concerned. So, whose fundamental rights are affected? You'll have to come to the citizen. You have to say that you have to somehow make out a case that the right of the citizen to get the person he has elected to continue to rule the state or the country is in some manner affecting your fundamental rights. Now that's a very large ask, but you will have to do something in those lines. This kind of, at your stage in study of law, you've both done extremely well. So these are issues which will come up at a much longer path. By the time you again get an opportunity to argue these kind of cases, you would have at least 15-20 years of practice. So by then I'm sure all of you will improve and get to that stage. So from all 3 of us, best of luck. We hope to see all of you in courts soon.